Mic on? Mic on? Alhamdulillah. والصلاة والسلام رسول الله وعلى آله وأصحابه ومن سار سبيله إلى يوم الدين أما بعد. So we'll continue discussing the book Al-Mulakis al-Fiqhi by Shaykh Salih Fawzan Hafidullah Ta'ala, and we have been covering concerning the bab of Mirath, and before he have some introductory masail to be covered. So of those things that he covers regarding Ahkam al-Wasaya, so of those things there's a part of the Ahkam of Mirath, of inheritance, is discussing concerning the person leaving behind a will. So we'll pick up from where we had stopped in that discussion and continue and hopefully to the end inshallah. تفضل.
بسم الله والصلاة والسلام على رسول الله. قال المؤلف حفظه الله. Chapter 2, title Wills, page 229. Imam Ibn Qayyim said, the soundest opinion is that the testator has the right to bequeath his entire property providing he has no heirs. That is because the lawgiver has forbidden bequeathing more than 1/3 only if there are no legal inheritors. So the one who has no inheritors can do whatever he wants with his money. If 1/3 of the testator's current money does not cover the amount of the money assigned to his bequest, and the heirs have refused to authorize the access over 1/3, then the amount of the portions of all the legatees is to be decreased, each one by virtue of his allotted share. There is no difference between the legatees mentioned first and those mentioned later in the bequest, because all of the bequeathed property is to be disposed of after the testator's death. Therefore, the bequeathed property has become due at the same time. Thus, the excess is to be deducted from the legatee's portion at the same time, since they, the legatees, equally share the property, but may differ in the amount deducted from each other's share, just as the case with the owl. Similar to this is the case wherein a testator bequeaths 100 riyals for a person, 100 riyals for a second person, 50 riyals for a third person, 30 riyals for a fourth person, and 20 riyals for a fifth person. Thereby the total amount he has bequeathed is 300 riyals. Yet 1/3 of his entire property is only 100 riyals. Thus each person is to be given only 1/3 of the portion he has allocated in the bequest.
Hey, that part is somewhat clear. So, clear?
Yeah.
Okay, type. So the person have bequeathed more than what he actually should. So instead, so all those people that he mentioned, they'll just get a portion, 1/3 of what they're deserving, not the full share. Aywa.
The validity or the invalidity of the bequest with regard to the legatees is considered at the time of the death of the testator. For example, if a person bequeaths to a legal heir and at the time of death of the testator, this heir becomes an illegal heir, such as the case of a brother who has been excluded of being an heir by the testator's newborn son. In this case, the bequest is considered valid at the time of death of the testator because it is the time at which ownership of a bequest is transferred from the testator to his heirs and legatees. On the contrary, if a testator makes a bequest for an illegal heir and at the time of death of the testator, this illegal heir becomes a legal heir, the bequest will not be valid. An example for that is the case of a testator who bequeaths to his brother while the testator's son is still alive at the time of the bequest, and this son dies after that. Thus, the bequest is considered invalid unless authorized by the other heirs because the testator's brother has become a legal heir at the time of the testator's death. Consequently, the acceptance of a bequest by the legatee is only relevant after the death of the testator and not before, and also the transfer of ownership of a bequest from the testator or his heirs to the legatee is only after the death of the testator, and it is not permissible for the legatee to accept the bequest before the death of the testator.
It's what I mentioned regarding of those ahkam regarding al-wasaya. So I mentioned regarding you might have certain cases where things might change. So the person might bequest for a person that a certain amount, but upon that cannot be fulfilled until that person dies. So we mentioned before regarding wasiya that whatever has been bequest, then it is not to be given to that person or transferred to that person until that person dies. So upon a person that certain circumstances might change. So in certain cases he mentioned that a person that he had bequests for him to receive certain things, but then certain circumstances change. So at times either the person will be included or excluded. So at times the person will be included where now he cannot receive what was given based upon his circumstance has changed, where he becomes one of the waris, he becomes one of the inheritors. So then now certain things change. So is also that the ruling change with that change of circumstance. Aywa.
There is no difference of opinion amongst scholars that the Al-Muwaffaq said.
Muwaqqif, well, هو ابن قدامة. So هو ابن قدامة صاحب المغني, صاحب المغني.
There is no difference of opinion amongst scholars that the validity of the bequest is considered at the time of the testator's death. If the bequest is to non-specific individuals such as the poor, the family of so-and-so, or for a public interest such as building mosques, then it is effective immediately after the testator's death, and the acceptance of the bequest by the legatee is irrelevant in such cases. But if the bequest is made in favor of a particular individual, then the ownership of the article bequeathed depends on the acceptance of the legatee after the testator's death.
Even the author, Hafidullah, he mentioned regarding that he knows that this book is meant for like beginners. So this book is meant for like beginners, but at times he may quote from some of the ulama that the books that he's quoting from are not for beginners. They're for the people at the, so it's not the people at the more advanced level. So he mentioned regarding concerning Ibn Qayyim Rahimullah's statement, and the statement of Ibn Qayyim Rahimullah, and those statements is taken from a book that is called I'lam Muwaqqi'in. I'lam Muwaqqi'in is a book for people who give fatwa. So that book is for people who give fatwa regarding concerning I'lam Muwaqqi'in and Rabbil Alameen. God concerning that like these are guidelines that a person should be aware of. The person want to sign off on behalf of Allah subhanahu wa ta'ala, meaning that a person that is passing judgment regarding Islam, so rules and guidelines and masail that he should be mindful of. Then he mentioned also Muwaffaq ibn Qudama and his book Al-Mughni. So said even though so at times he may take from these books that are said not of more advanced level in matters that are somewhat clear, in matters which is clear, we might find that these books by themselves, for beginners, you would not be told to read those books. But at times to take points from those books, even for a beginner, then it can be done. But to kind of somewhat direct and advise a beginner for him to start by reading the book of Mughni in fiqh, it's a high level that you wouldn't advise such a person, a beginner, except for the person who's on that level. Now the person has to be on that level for him to actually read that book and to completely benefit from. Aywa.
The testator has the right to revoke his will by a subsequent will, or nullify it completely or partially. To illustrate, Omar radiallahu anhu said, one has the right to change whatever one likes in one's bequest. There is also an agreement amongst people of knowledge with regard to this matter. If a testator makes some article a bequest, but then says, I change my mind, or says any word which implies that he is nullifying his bequest or part of it, then his bequest is nullified. That is because the time of death of the testator is the only relevant time with regard to the validity of the bequest and the acceptance or the rejection of the bequest by the legatee. Thus, the testator has the right to revoke his will during his lifetime.
And so it shows regarding wasiyah that everything what is the main factor is regarding the person is death. So while he's still alive, that he can change his mind if he wishes, he can undo what he has done. So he has that right while he's still alive. But upon death, then everything has to be carried through. Then everything has to be administered as he had stipulated. Unless we said he have certain they think that he did that was incorrect.
Legati.
Legate.
The one that's going to receive.
The one receiver. They were the word they use inside, but the receiver and aywa.
The one that will carry out the.
No, the one receiving.
The one receiving.
The one receiving. Aywa.
For example, if a testator says, if X comes, I bequeath to him what I have bequeathed to Z, and X has come during the testator's lifetime, then the bequest is to X, and in such case the testator's bequest to Z is nullified. However, if X comes after the testator's death, then the bequest is to Z. This is because the testator's death has been before the arrival of X, thus the bequest has been settled and transferred to Z. Obligatory expenses such as debts and religious obligations like zakah, expiation, vows and hajj must be paid first, whether mentioned in the will or not, as Allah exalted be He says, after any bequest which was made or debt. Surah Nisa, Ayah 11. Ali ibn Abu Talib radiallahu anhu said, the Messenger of Allah sallallahu alayhi wasallam decreed that one's debt is to be settled before one's will is carried out. Related by At-Tirmidhi, Ahmed, and other compilers of hadith.
I mentioned regarding concern that hadith that is mentioned by Ali ibn Abi Talib radiallahu anhu, that قال رسول الله صلى الله عليه وسلم أو قضى رسول الله صلى الله عليه وسلم بالدين قبل الوصية. So regarding concerning of those things, that if the person make these bequests, then those things are carried out after looking first to see is there any debt that he owes others, or debt that is owed. So those things like concerning debt, they will be paid out first before any those requests or bequests are made. And also they mention here regarding concern of those things that is to be considered regarding concern from a person's wealth, that if there's thing which is wajib that was not fulfilled, regarding concerning wajib by way of religious duties, so of those things regarding the person, that and of those things of concerning duyun, that to be fulfilled, also of those things which is wajib, that a person so the person and financially was able to regarding concerning hajj but did not perform hajj, then also from what he has, then that amount can be taken and a person make hajj on his behalf, because he was able to afford it but did not carry it out for whatever reason was. So those things can be taken from his wealth that he leaves behind and be used for that purpose and other things. So regarding and also zakat, so the person also that upon death that he did not pay his zakat at that time, then also those things is to be taken out. So zakat, so thing which you consider to be religiously wajib, then those things to be carried out, and of those things including debts. Aywa.
According to the aforementioned, paying debts comes before fulfilling the will. It is recorded in Sahih al-Bukhari's authentic book of hadith. So fulfill Allah's rights, as He is more entitled to receive His rights. Thus, according to the consensus, the sequence of rights is as follows. Debts are to be settled, the bequest is to be fulfilled, and then the remaining property is to be divided between the legal heirs. It should be noted that...
So I mentioned regarding concerning, so the persons, when a person died, regarding what he leaves behind, then as to those things regarding concerning those things which is wajib would include concerning dain, and of those dain could be dain that are debt that is owed to others, other people, or companies or whatever. So any type of debt that is owed, then those things to be fulfilled and taken from his property or his belongings. And also of those things that includes regarding concerning that matters regarding that of debt. But the person said, no, you have any religious obligation that was not fulfilled. So for example, of that concerning zakat, if he has wealth to see, is zakat to be taken from his wealth. Also regarding concerning, if for example hajj was wajib upon him, and it was not fulfilled. So the person had the wealth, but he was very ill. Now, so he was unable to undertake performing Hajj. Then also it can be taken and someone perform Hajj on his behalf. So those things are things that to be looked at first. Then the next thing to be looked at regarding concerning wasiyah. There's anything that he bequeathed to anyone. So those things are given as those things was done while he was alive and meant to be passed on to others. Then the third step would be concerning then whatever remain that is given to his inheritors. So whatever remain would be given to his inheritors. Aywa. We mentioned that the hadith that is mentioned, the hadith is da'ifa. The hadith was said that in Tirmidhi, that the hadith of Ali. So that hadith they mentioned that al-Bayhaqi da'afahu'i, or the hadith to be da'if. Aywa. The hadith of Ali, that concerning that ad-dain qabla wasiyah. Ad-dain, that debts before wasiyah. That hadith is da'if, according to Bayhaqi. Aywa.
It should be noted that the bequest is mentioned before debts in the aforementioned noble verse, despite of the fact that debts take precedence over the bequests when fulfilling them. This is because, similar to inheritance, fulfilling a bequest is granting property with no compensation, so the inheritor carries it out with great difficulty. Thus, the bequest is mentioned in the above verse before debts in order to urge inheritors to carry it out and to emphasize its importance. It is noteworthy that the conjunction or, which indicates equality, is used in the verse after any bequest which was made or debt, in order to stress that both things are equally important, although debts take precedence over the bequest when fulfilling them. Accordingly, the will is of a fundamental importance. Allah Exalted Bihi mentions it in the Noble Quran and gives it precedence over other matters, thus stressing its importance and encouraging people to fulfill it as long as it complies with the Islamic rulings. However, Allah Exalted Bihi warns whoever neglects the will or changes it without any legal excuse. He, Exalted Bihi, says, then whoever alters it, i.e. the bequest, after he has heard it, the sin is only upon those who have altered it. Indeed, Allah is hearing and knowing. Surah Baqarah, ayah 181.
Aywa. I was listening to one of the Mashaykh a couple of days ago, and he was saying that regarding concerning that there are certain things in general that might be said to be fardul kifaya. That is the ruling that is something which is fardul kifaya upon the ummah. But at times that matter could be fardul ayn. And at that time when something becomes fardul ayn is to one consult those people who are specialists in that field. So said in the time concerning a person have passed on, have died, then maybe and a person has wealth. So the person doesn't have much wealth, and a person who has wealth, then becomes maybe at that point it becomes maybe fardul ayn to consult people regarding how to distribute that person's wealth and how to settle his wealth. So everything is done done in the proper order. So we might find that yes, because so at the time of death and certain things that might arise, then that because of that situation, it becomes upon those who are somewhat leading on that matter that they consult the right people to make sure they're given the right advice and everything is put in its proper order, shar'an, according to the Sharia. So as I mentioned, regarding concern upon that there's certain order regarding how to distribute that funds of those things that to be looked into regarding duyun, the person of any debt, also that is outstanding, also the person of any wasiyah, any form of will that he has bequeathed certain things to people, and also then last concerning the tarika, which is the person's inheritance. So you don't know how to put those things in order. So it requires concerning a person of ilm. Require a person of ilm to look into those things in its proper order. Aywa.
Imam Ash-Shawkani in his exegesis of the Quran.
I mean tafsir the Quran. Concerning tafsir.
I'll use that one next time.
So let's say something, let's say a tafsir the Quran, which is more familiar word with us. Let's say tafsir. The tafsir called Fathul Kadir. So Shawkani rahimullah that he has a tafsir called Fathul Kadir, that a useful tafsir. Aywa, this is in print. Aywa.
Of the Quran stated, altering means changing. It is a threat from Allah to whoever alters a legally valid will which does not harm anyone. The sin of altering the will shall befall those responsible for altering it, and there will be no sin upon the testator, for he has absolved himself by making a bequest. A bequest is permissible to be made in favor of anyone capable of possessing such bequest, whether a believer or disbeliever.
So the question was asked last regarding concerning that, this is answer that question, huh? That was the question we asked last week, or someone asked. Regarding concern is not that a person might make in his will that he may
put a non-believer
to a non-believer.
Yeah.
So it is something which is permissible that you might bequeath a certain things to a disbeliever.
And then if a disbeliever puts a believer in his will,
and then a vice versa.
it's just gift.
That is a gift, yeah. And not the inheritance will be per se as a gift. Aywa.
This is due to Allah's statement, except that you may do to your close associates a kindness through bequest. Surah Al-Zab, ayat number 6. Muhammad ibn Hanafiya said, this verse refers to the bequest of a Muslim to a Jew or a Christian. Moreover, Ibn Khattab radiallahu anhu gave his polytheist brother a garment stripped with silk. And Asma gave a gift to her mother, though the latter was a disbeliever. And Safiya, mother of the believers, bequeathed 1/3 of her property to her Jewish brother. Allah exalted be He says, Allah does not forbid you from those who do not fight you because of religion, and do not expel you from your homes, from being righteous toward them and acting justly toward them. Indeed, Allah loves those who act justly.
So regarding concerning the ayah is a proof concerning that of those things regarding one's relationship with a kafir or a non-Muslim, that that of those things that it is allowed, that of al-bir, being good towards them, that a person can give them of things, he also can accept gifts from them. So you can give and also accept from them. Aywa.
That was Surah Mumtahina, ayah 8. Bequeathing to a particular non-Muslim individual is valid, as previously mentioned. However, it is impermissible to bequeath to disbelievers in general. For example, if one bequeaths to a Jew or Christians in general, or their poor people, then his bequest is considered invalid. Similarly, it is impermissible to bequeath anything which must not be owned by a non-Muslim to a particular disbeliever, such as the noble Quran, a Muslim slave or arms.
There's a certain thing, so it shows regarding that mentioning regarding that in bequest to the kuffar, that a specific person can be done, but in generalized concerning that in generalizing, then no. So it has to be specific regarding who amongst the kuffar, the disbelievers, one is bequesting that thing. Aywa, and also certain things that a mushaf wouldn't be given to them. So a mushaf wouldn't be given to a Muslim, or weapons or the likes. So those things would not be something that is allowed to be given to them. Aywa. What's that? Silah?
It's not
Not to be given.
specific believer or a general believer. Because it's very
Comes like a more. Comes bequesting to them like a mushaf, Quran. So that would be considered general. So you wouldn't give a kafir a Quran. Or I mentioned concerning that an Abdul Muslim or silah. So silah mean like weapons. Clear? Clear, Quran? In that sense, and so because of safety matters, and also concerning Abdul Muslim, a Muslim may be a slave. You wouldn't per se give him to a kafir, as he then becomes under a kafir. And we said the Musaf because it's a religious text for the Muslim, So those things, they're exempt. Aywa.
Bequeathing to a person yet unborn is permissible, provided that the child is either born alive with 6 months of the time the bequest is made, if the mother has a husband, or is born alive within a period less than 4 years after the bequest is made if the mother is husbandless. Such fetus legally inherits thereupon bequeathing to it is permissible with greater reason. However, if the child is born dead, the bequest becomes invalid. Nevertheless, a bequest is to an unborn child who has not existed at the time during which the bequest is made is invalid. For example, if one says, I bequeath such and such a thing to the child whom this woman will be pregnant with, then this bequest is invalid since he is bequeathing to a non-existent person. If the testator bequeaths a great amount of money for performing Hajj on his behalf, then the bequeathed money should be fully paid for doing as many times as can be until the money is exhausted. But if the bequeathed money is little, then it must be paid in doing pilgrimage on behalf of the deceased according to its amount. However, if the testator stipulates that the big amount of money he has bequeathed is to be spent in one Hajj on his behalf, then it must be spent in one Hajj, for he has intended by doing this the benefit of the one performing Hajj on his behalf. In such cases, it is not permissible for the exetor or an inheritor to perform Hajj on behalf of the deceased because the testator apparently specified another one to perform Hajj on his behalf. Bequeathing to anyone who is not capable of possessing the bequest is invalid, such as bequeathing to a jinni, an animal, or a dead person. Needless to say, nothing in the will should be contrary to Sharia Islamic law, such as bequeathing to churches or temples of disbelievers and polytheists. Similar, it is impermissible to bequeath to keeping or lighting graves or to the gatekeepers of these graves, whether the testator is a Muslim or disbeliever.
All these things lead to a shirk. These things are a part attached to shirk or kufr.
Shaykh al-Islam Ibn Taymiyyah said, if a Jewish or a Christian bequeaths a portion of his property to their temples, then Muslims must invalidate this bequest, because they must judge by what Allah has revealed, and Allah has revealed that Muslims must not cooperate in aid of disbelief, defiance or disobedience to Allah. Thus Muslims must not fulfill a bequest to places wherein people disbelieve in Allah. Similar, it is impermissible to bequeath to publishing abrogated books such as the Torah and the Gospel, or publishing perverted books such as books of atheism.
And also books of al-bidah wal-kufr. So all those also be included.
According to what this is here with Shaykh al-Islam, if a Jew or Christian bequeaths a portion of his property to the temples, so
so the Muslim shouldn't
assign it.
The Muslim shouldn't per se carry through. Now the Muslim, as a Muslim, kind of somewhat is guide. It may be within something that is allowed amongst them, but for the Muslim who's overseeing and involved, then he cannot carry through it because he's assisting in something which is contrary to Islam.
So they should be the administrator of that.
So the Muslim, the administrator, he shouldn't per se fulfill this as it goes contrary to Islam. So the Muslim judge himself, another Muslim, and even a Muslim by Islam. So the Muslim all the time he rules by Islam.
So can a Muslim be the administrator of a non-believer as well?
And they could be done, but if there's anything that contrary to Islam, then he cannot carry through.
What would he do with that portion?
Then that becomes the ijtihad of the concern. Maybe that money would go back to the original inheritance. Go back to the original because it's considered to be invalid. So let's go back to the original inheritance.
So it goes back into the pot and split.
Go back into the pot.
What is the only child?
Sorry?
What is the only person in that inheritance? Is the only person?
Then he gets everything.
Yeah, he just swallows it, innit? Just takes it.
Yeah, the person be created that certain things to be done. For example, the person's a Christian, for example, and they bequest that X amount of my money, a third of it to build a church. or to renovate a church, then you cannot fulfill that. So that money go back, we said, into the pot of the inheritance. Because that something is batil.
And in that case there, if that person has no parents, nothing except for one child,
And then they receive everything.
that child just gets the money.
And I will discuss concerning if there's only one person they receive everything.
It is a necessary condition for the validity of a bequest to be of legal money or of utilizing something permissible, even if the item bequeathed is something undeliverable, such as a flying bird, an embryo, the milk in the udder of a milch animal, or something not yet existent. For example, someone may bequeath the fruits of a tree forever, or for a certain period, 1 year for example, or he may bequeath what a certain animal may deliver. In such a case, the bequest is for the legatee only when such inexistent things materializes. However, if such inexistent things do not materialize, then the bequest is considered invalid, for in such case there is no bequeathed item in fact. Among things that may be bequeathed is something or someone unknown, such as bequeathing an unknown animal. In such a case, the legatee is given anything by that means, in reality or accordance to custom. If the testator bequeaths 1/3 of his estate, and after making his bequest he gets more money, then his extra money will be included in his bequest. This is because the 1/3 is considered from the entire property owned by the testator at the time of his death. If the bequeathed property is damaged before or after the death of the testator, then the bequest is considered invalid and the legatee's right is terminated due to the damage caused to the bequeathed item. If the testator does not define the amount of the bequeathed item, such as bequeathing a share from his money, then this share is to be set as 1/6. This is because in the Arabic language, a share indicates 1/6. This is the opinion of Ali ibn Abu Talib and Abdullah ibn Masud in this regard. In addition, 1/6 is the least prescribed share. Therefore, it is referred to in indicating the undefined bequeathed share. If a testator bequeaths some of his property to a legatee and he has not specified the amount of the bequeathed property, then the inheritor is to give the legatee any amount of money, since the word sum, linguistically and legally, does not imply any specific amount. So the word sum can refer to anything that is considered property, and whatever is not considered a property does not fulfill the bequest.
Okay, so discuss concerning the language that may be sometimes used. So the language at times, so it's somewhat mubham, somewhat unclear. I use a word concerning sahm, that is taken as sahm, that's considered that is taken as 1/6. Or I mention an awsa بشيء من مالي. So the word min malihi that I mentioned, so those words, because they're not specific, then it will, regarding concerning that المتبين. So it goes back to, so the old language is used and understood regarding those cases that are somewhat unclear.
Rulings related to the executor. The executor is the person who is appointed by the testator to dispose of the estate after the testator dies. This is to say, the executor is in charge of all the testator has been in charge of during his life. So the bequest executor is the testator's deputy. Accepting this deputyship, i.e. to be the executor, is desirable and is considered an act of worship by which one attains nearness to Allah. Yet this deputyship is permissible only for the one who has the capability and the honesty to undertake the bequest. Allah exalted be He says, and cooperate in righteousness and piety. Surah Al-Ma'idah, ayah number 2. The Messenger of Allah sallallahu alaihi wasallam said, Allah helps a person as long as the person helps his Muslim brother. Also, the Prophet's companions used to assign deputies to dispose of their properties after their death. To illustrate, a group of the Prophet's companions appointed by Az-Zubair ibn Awwam to be the executor, Abu Ubaidah ibn Jarrah appointed Omar ibn al-Khattab as the executor of his will, and Umar ibn al-Khattab appointed his daughter Hafsa, may Allah be pleased with her, as his executor, and also assigned the eldest of his sons to take over the position successfully after her.
Hey, so it shows regarding concern that at that point in a person as one to oversee of things, then that is something which is allowed. And they mention concerning from this, concerning from that concerning from Babu Ta'awun al-Bir wa Taqwa, of cooperating those things of Bir wa Taqwa, and also regarding concerning that he mentioned also from the Salaf that they also would apply this. So they mentioned regarding concerning of the Sahaba who appoint people to be the executor of their property. And although they mentioned cases, even the case they mentioned concerning that Omar, that he placed who was in charge, his daughter. So you should have to know that a person, the father, or that person can place a female in his family to be the one to be in charge. So she's in charge of his property and the son in charge of the business. Aywa.
As for the one who has not the capacity of to properly undertake the bequest, or feels that he might waste it, then it is impermissible for him to accept this responsibility.
So for the person to know himself, to know what he's able to can take on and fulfill that responsibility accordingly. If he believes that he's not capable, then he should not accept it, because would be a sin upon himself to do misuse of that funds, or not to fulfill those responsibility properly. Aywa.
The executor of the bequest must be a Muslim, as it is impermissible to appoint a non-Muslim to be an executor of a will.
So the condition that the person executed should be a Muslim.
Moreover, the executor must be legally accountable, for it is not valid to appoint a little boy, an insane or a foolish, weak-minded person as executors of wills, because they are not capable of undertaking guardianship responsibilities. Yet, one may appoint a boy to be the executor when that boy reaches legal majority, as the Prophet ﷺ said concerning the battle of Mu'tah, when he appointed Zayd as the commander of the Muslim army. If Zayd is martyred, Jafar is to take over his position. Appointing a female executor is considered valid, provided that she has the ability to undertake the bequest responsibilities. This is because Umar ibn al-Khattab appointed his daughter Hafsa as the executor of his will. Moreover, a woman can be a legal witness, hence she can be appointed as an executor of a will. So for instance, with that now,
Aywa. With a female.
She can be a legal witness.
Yeah.
Equal to a man, one for one.
Not in every case, not per se in all cases, but in general, they can be a legal, so not a witness, but it might varies, but depending on the situation. But they still can be they are witness. They can be a valid witness, but it may varies depending on the case that is at hand or the situation.
So for marriage, 2 men, 4 women.
So if you could go that route,
Yeah.
you could go that route.
And then for legally, 1 man, 1 woman.
So the normal thing that 1 man, 1 woman, unless those cases where the Sharia stipulate otherwise.
Okay.
Yes, so unless the Sharia specify otherwise. So the general rule is that men and women are equal unless the Sharia, unless the Sharia say otherwise. They share same rights unless the Sharia says otherwise.
It is also valid to appoint an executor who cannot practice the work by himself, provided that he is of sound reasoning and can appoint another honest one to help him. In addition, it is valid to appoint more than one executor, whether they are appointed by the testator at the same time or one after another. If the testator appoints more than one executor, then they should manage the bequest collectively. each executor should not act independently of other executors, i.e., their acts proceed from the decision of the group. If one of them dies or is absent, then those in authority are to appoint another one instead, who must be capable of undertaking their responsibility. Appointing an executor of the bequest is considered valid if the executor accepts this responsibility while the testator is still alive or after his death. Moreover, both the bequest executor and the testator has the right to cancel this appointment whenever they wish, i.e., before or after the testator's death. This is because the executor is just a deputy. It is impermissible for the bequest executor to appoint another executor unless the testator authorizes the executor to appoint whomever he chooses as executor of the bequest. The items in the will must be known and defined so the executor of the will can uphold and dispose of these items. The testator must have the legal authority to dispose of whatever he bequeaths in his will, such as paying a debt, distributing the bequeathed third, looking after the welfare of his children, and so forth. Consequently, the bequest executor undertakes the bequest according to the permission from the testator. Thus, as in the case of deputyship, the bequest executor cannot dispose of anything which the testator does not have the legal authority to dispose of. Moreover, the testator is the original owner, and the bequest executor is his deputy. Consequently, the deputy does not own what the original owner does not actually possess. In brief, it is invalid for the testator to bequeath what he does not really own, such as the case wherein a woman testator appoints someone as the guardian of her children. This appointment is considered invalid, since guardianship is only for the father. The authority of the executor of the will is limited to what the testator has specified, i.e., if the executor is appointed by the testator to pay his debts, then he does not have the legal right to act as the guardian of the children. Thus, like the deputy, the executor's duty as an executor of the will is limited to what the testator has authorized him to do. It is valid for the bequest executor to be a Muslim if the testator is a non-Muslim, provided that the testator's estate does not include anything legally prohibited. So if the testator's estate includes what is forbidden, such as liquor or swine, then this appointment, the appointment of a Muslim executor, is invalid. This is because it is impermissible for a Muslim to be in charge of such prohibited things. If the testator says to the executor, for example, I authorize you to distribute the bequeathed third of my property as you wish, or I authorize you to spend the bequeathed third in charity among whoever you wish, then it is impermissible for the executor to take anything of this money for himself, because the testator has not permitted this. Moreover, it is not permissible for the executor to give his children or his heirs anything from this money, because in this case he is more likely to be biased towards them.
Okay, so I mentioned that point regarding, so the first mentioned that if you wish, that doesn't include yourself.
Yeah.
So it doesn't include yourself. And you want?
If someone dies in a place where there is no governor or guardian, such as someone dies in a desert, then it is permissible for one of those who are present to manage his estate and do what is appropriate, such as selling his estate and the like. That is because it is a state of necessity, for if his estate is left, it will be spoiled, and protecting that person's estate is a collective duty. It is worth mentioning that funeral expenses in such cases are to be paid from the estate of the deceased.
Hey, what? Hey, that's it?
That's it.
Hey, that's it. What's the last thing mentioned? من أحكام وصية أن من مات بمكان لا حاكم فيه ولا وصية. What he mentioned regarding the last sentence or paragraph, what he mentioned, that أحكام الوصية.
If someone dies in the desert.
From the top what it says? The one who dies in a...
If someone dies in a place where there is no governor or guardian, such
the
as
hakim, concerns the hakim, so the hakim shari. So a person die in a place where there is no person, like Islamic court system in place would be like us living in the West. So it would be like us living in the West. Aidan mentions what?
Such as someone dies in the desert or the West, then it is permissible for one of those who are present to manage his estate.
Even the Muslim, man hadarahu min al-muslimin. So one of the Muslim,
manage his estate, and to do what is appropriate, such as selling his estate and the like.
There's Muslimin present in that sentence.
No, he doesn't say. It just says those who are present.
And so those says جاز لبادة من حضر من المسلمين. So the word Muslimin needs to be added. So of those present amongst the Muslims. So it could be taken there as anyone who's present, Muslim and Muslim alike. But what I mentioned, min al-Muslimin, so meaning to not one present from amongst the Muslim, that a person died in a place in the isolated area, there is no Muslim except for a few, then one of the Muslim present, there's no Islamic council or Islamic court, then one of the Muslim present, then the responsibility upon them. So the word missing there is min al-Muslimin. That is important. So that inshallah ta'ala, we have completed that portion, or this portion of the book, and inshallah ta'ala we'll continue maybe not the week after, not next week, because of a visit. So we have one of the Mashaykh from Misr who's visiting, and will be until about over the weekend and leave on Monday type of thing. So we just break until after the visit. After that, he's going to be here for over this weekend, starting from this week, which will be from Thursday. That will be in the book of Ibn Majah, Sunnah Ibn Majah, from the book, the first chapter, which is Kitab as-Sunnah. So that book that chapter discusses concerning the emphasis of sticking to the Sunnah and the likes and the importance of the Sunnah. So that will be covered from Thursday through till Sunday. But then you should be traveling on the Monday. So we just skip that day, so just to make sure to see as to what happens that day. We're unsure as to what might happen that day, Monday. So inshallah ta'ala will be meet up the week after, inshallah ta'ala, and we start concerning Bab Mawarith. Wabillahi ta'ala tawfiq.